Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. Today, we bring you an important September 2025 Supreme Court judgment that clarifies how even a small typographical mistake in a legal notice can cost the entire case under the Negotiable Instruments Act. The case is Kaveri Plastics v. Mahdoom Bawa Bahrudeen Noorul. Criminal Appeal Numbers 00414 to 0041443 of 2025. Decided on 19th September 2025. SC Bench, Chief Justice Bhushan R. Gavai, Justice N. V. Anjaria, and Justice K. Vinod Chandran. Let's understand the entire background, legal issues, court's observations, and the impact of this decision on check bounce cases under Section 138 of the Negotiable Instruments Act. Background of the case. Kaveri Plastics, the appellant, entered into a Memorandum of Understanding on 30th April 2012 with MS Naftogaz India Pvt Limited, the accused company. The Memorandum of Understanding was for the sale-lease of a piece of land. As part of the financial settlement, the accused issued check number 876229 dated 12th May 2012 for 1 crore rupees, drawn on Indian Overseas Bank, RK Puram, Delhi. The check was dishonored due to insufficient funds. Kaveri Plastics sent two statutory notices under Section 138 NI Act, dated 8 June 2012 and 14 September 2012. However, in both notices, the demand made was 2 crore rupees, double the check amount. This error, claiming 2 crore rupees instead of 1 crore rupees, became the central issue of the case. Procedural history. A criminal complaint was filed under Sections 138, 141, and 142 of the Negotiable Instruments Act. The accused filed an application for discharge, stating that the demand notice was invalid due to the wrong amount. The Metropolitan Magistrate dismissed the discharge application on 6 October 2021. On revision, the Delhi High Court, in its order dated 26 February 2024, quashed the complaint entirely, holding the notices defective. The complainant then appealed to the Supreme Court, which led to the current 2025 judgment. Legal issues framed. 1. Can a statutory demand notice under Section 138(b) be considered valid if it demands an amount different from the check amount? 2. Can the defect in amount be cured by calling it a typographical error? Arguments of the parties. Appellant's arguments, Kaveri Plastics. The discrepancy in the amount was a clerical or typographical error, not intentional. The High Court's approach was too technical. The notice must be read as a whole and the check amount was otherwise mentioned. Respondent's arguments, Mahdoom Bawa Noorul. Section 138(b) requires strict compliance. The demand notice must specify the exact amount of the dishonored check. Since the notice demanded more than the check amount, it is legally defective and the complaint must fail. Court's observations and findings. The Supreme Court held. Section 138(b) uses the phrase, said amount of money, which refers precisely to the amount of the dishonored check. Strict compliance with statutory provisions is necessary because Section 138 is a penal provision. Even if the error was inadvertent, it cannot be ignored because the error occurred in both notices. The court rejected the argument that the error was curable or could be overlooked under a liberal interpretation. Key principle: a defective demand notice, even if the effect is due to a copy-paste mistake, nullifies the complaint under Section 139 NI Act. Final judgment. The Supreme Court dismissed the appeal and affirmed the Delhi High Court's decision. As a result, the criminal complaint stood quashed due to the invalid statutory notice. Future impact of the judgment. Implications. 1. Drafting notices with precision. Legal practitioners and companies must draft statutory notices carefully, ensuring the amount demanded exactly matches the check amount. 2. Zero tolerance for errors. Even typographical or clerical mistakes are not excusable under Section 138. Notices must comply strictly with the wording of the Act. 3. More scrutiny in check bounce cases. Magistrates and high courts are likely to apply a stricter lens in such matters, making meticulous compliance essential. Conclusion. This 2025 judgment sends a clear message: accuracy in legal process matters. A small mistake can lead to the collapse of your entire complaint. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind!